SJC-13106, Kyana Jinks v. Credico USA LLC.
Okay, Attorney Lichten, whenever you're ready.
Thank you. May it please the court, my name is Harold Lichten. I have the pleasure of representing the plaintiffs in this case. In this case, the lower court simply refused to apply Section 148B to determine whether Credico was an employer of the plaintiffs, solely because he concluded that plaintiffs, quote, were not directly providing services to the defendant. Okay. That conclusion was erroneous, given the particular fact of this case, where it is undisputed that 100% of Credico's business was created by the sales and marketing agents that my plaintiffs were part of, and all of the income of the intermediaries and of the plaintiffs came from Credico.
Okay, counsel, before you go too much further, can you just be a little particular with me about what exactly you're appealing from? I wasn't 100% sure from the notice of appeal. It says the appeal is from the court order granting summary judgment to the creditors. There seem to be other rulings in there that were not necessarily addressed by your brief, but also you agree that your second request for to appeal the grant of summary judgment to all defendants, which was part of the order. The other defendants have been kicked out of this case, correct?
Yes, this case.
So what's your focus? What's your scope?
This case only involves the decision by the court to grant summary judgment to Credico on the question of employment status, thereby prohibiting my clients from establishing that they were deprived of minimum wage and overtime with respect to Credico. Okay. The other intermediary defendants are long since gone. Okay. We're also appealing the decision to grant summary judgment or grant judgment against Mr. Jackson because of his participation in a federal FLSA opt-in case. And we're also appealing, the third thing that's very important, the decision of the judge to conclude that the overtime statute did not apply to the plaintiffs, where the statute here in Massachusetts.
Can I turn to that one? Because your reading of that just seems to be wiping out joint employer law. I mean, here we have a case in which the person is, we don't have to decide whether the employee is an employee or an independent contractor. The employee is an employee, right?
No.
Yes, bear with me. He's an employee of the other company, right?
No.
He's not? He's not treated as an employee of that company?
For most of the time at issue, they were all independent contractors. So up until this case goes back to 2013 because it was filed in July of 2016, so the statute of limitations would go back to 13. At the end of 2015, after Credico was sued in New York, Credico put out a memo saying we'll no longer allow the intermediaries to have independent contractors. They also put in an arbitration clause, which is in the record. It's not really part of this case. And so it's likely that there's no class post-2015 because of the arbitration clause. But these workers, and two of my plaintiffs in this case, were independent contractors. We don't think that 148B requires independent contractor status to apply the test, but they were independent contractors.
So I'm trying to figure out how we do these cases because they're so complicated. I understand when, okay, maybe we take your first couple of years where there's no commitment that someone's an employee. But once we have someone being an employee of one company, that test is so broad that it's going to confuse employment status. I mean, because no one's going to meet, I mean, the issue of joint employer is sort of an exceptional circumstance, not a normal circumstance. We want one employer to have all the obligations, and the way you're doing this is we're going to have two employers a lot of the time, and that has significant consequences because if you don't pay wage acts, you're subject to personal liability if you're the CEO or the treasurer of these companies. It just seems like the judge is doing it intelligently to me. He's making a determination, okay, the person's an employee of one company, and then we got to use the joint employer test. I just don't understand how your test is going to work in the real world.
Okay, well, first, the primary part of this case doesn't involve employees. But I'm saying, and I think the law is clear, and I think Section 148B is clear, that under that test, which has been applied in Sebago, which is applied by the appeals court in Gallagher, you first look to whether the person is providing services or not. That's the
But
key.
again, when we're dealing with independent contractors, and there's a sense of manipulation of that, I get it. We have to use that test. But once we can establish that there is one employer, that test has the potential of creating a lot of confusion between who the employer is.
Your Honor, in some cases, that may be the case. But in this particular
Almost
situation,
every case, right? 'Cause
Your Honor, in this situation where Credico gave 100% of the intermediary's business, and there were 200 intermediaries that were created, was from Credico. They only had business that Credico assigned them, and it was 100% of their work. And my clients, all of their income, anything that they made, all of the services they provided were for Credico.
Let me give you an example, though. Okay, so you're a law firm. You have one major client. Does that make you the employee of that client? I mean, a lot of businesses have one good client. I'm just not sure that's the test, right? It's whether you control it's the classic joint employer test that the judge applies, isn't it?
Well, how then would you explain the several comments by the SJC, by this court, on numerous occasions, that we're going to look at arrangements and not allow arrangements that seek to get around the wage statutes?
I get it in the major case on point. The court was confronted with someone who's an independent, described as an independent contractor by two employers, and we're saying just because there isn't a contractual relationship, because you have to sort out whether the person's an employee or an independent contractor in that case. You have to. And I get that we have to do that, but once we determine that one person's the employer, you're just going to make everybody a joint employer. If we, there's going to be almost no one who's not a joint employer if we applied that three-part test.
No, Your Honor, I'm not saying that. In all fairness, what I'm saying is that in the particular facts of an arrangement like this, as commented by the Department of Labor in its opinion letter on vertical employment, and as commented by this court, where you have these facts, where you have 100% of the business of the intermediaries is derived from Credico. They control the intermediaries. The intermediaries would have nothing to do. They can only go out and sell in areas that they're assigned. And when you have the workers who have no other work to do other than the work of Credico, selling their products in the territories that they're assigned.
So on your facts, and we'll put aside the discrepancies in the factual record, on your facts, then you'd win under the control test or the economic realities test on your facts. What I don't understand at all is whether somebody is an independent contractor or an employee has to do at all with whether somebody is an employer. I don't even begin to understand how the differentiation between an independent contractor or an employee determines who the employer is for the purposes of a joint employer.
Okay. Well, it may be that we're spending too much time on this because the primary part of the case involves the independent contractor. But I would posit to you that if you read 148B, and as other courts have found, it doesn't say anything about independent contractors. It talks about...
But there's an amendment pending, isn't there? An amendment to the law pending, wanting to do something like that?
There may be, but there's nothing now. When these clients have their case, the Section 148B simply says that persons performing service not authorized under this chapter deemed employees. And it says for purposes of this chapter and Chapter 151B, which is where our claims are, an individual performing any service except as authorized under this chapter. But I'd like to move on because, again, the employee part of this case is a small or non-existent part of the case. I am here on behalf of my clients who, for most of the time, were independent contractors, as were the hundreds of other people around the United States who were worked for Credico intermediaries.
But don't we have to decide how we decide who is an employee in this case?
Well, finishing on what Justice Kafker said, you may not have to get there. I would like you to get there, but it's clear that these workers were independent contractors for most of the time, and I heard him saying, I thought...
Aren't you saying the opposite? That
What?
you're saying they're misclassified as...
Misclassified,
Yeah.
yes.
You're saying, I mean, I get it. I understand we have this initial test where we have to figure out whether they're independent contractors or employees. I get that, and the legislature is super protective of making sure they're employees unless those three-part test is met. So I get that part of this. What I don't get is, once you figure out who the employer, once you figure out their employees, then we need a second test. It's not the first test. And the second test seems to be a traditional joint employer analysis, because again, it's an oddity and rare, but you're taking me somewhere I don't understand yet.
Yes, I disagree with that added step analysis. If the worker, let's just take for this purpose, is an independent contractor, then to determine whether or not they're an employee of a particular company, you apply the 148B test. Now, we know that from Sebago.
But that doesn't work, because it doesn't, it's so hard to meet that independent contractor test if the answer is always you're an employee to both companies. You're going to wipe out that distinction between joint employer and single employer.
But, Your Honor, in fairness, that is not true, because if you look at the Sebago case, which I think is the leading case, Sebago was a case where the cab drivers sued the medallion companies, they sued the garages, and they sued the dispatchers. And Justice Cordy said you have to look at each company and apply the test, and the first part of that test is whether or not they were providing services for that entity. And the court found, and I can understand why, that they weren't providing services for any of those companies because the services they were providing were to the people of the public for whom they gave rides. They just rented those taxi cabs, and after that, they could do whatever they want.
That makes complete sense in that context where nobody is taking responsibility for them. And by the way, we don't decide that they're all joint employers in that case, right? We just decide they're not independent contractors. And
Of those
therefore-
companies.
Right, they're not independent contractors, but we don't say these are all joint employers, do we? That they're all responsible for the Wage Act violation? But
Yes, I think the fair reading of Sebago is that if Justice Cordy had found that the workers were performing services for, let's say, the medallion company, then 148B would have applied to that particular company, and it's likely, not necessarily.
they get triple damages from every single one of those companies?
No, because some of them the plaintiffs weren't providing services for those companies.
Well, but if there's multiple employers in your context, just what you're saying there isn't I don't know. Anyway, I'm distracting you, so you
Can I
go.
ask you a slightly different question on the facts of this case?
Yes.
Why are your clients, under your tests, not employees of Verizon?
My guess would be that would be a step too far because.
But I'm just applying the test that you suggest, right, 148B. And under 148B, if you apply the test as you suggest it should be applied, I conclude they're employees of Verizon. Where does it end?
Well,
That is, we have an obligation to interpret statutes with common sense. And it sounds like you're saying it lacks common sense to extend this to Verizon, but they're providing services for Verizon.
they are providing services for Verizon.
But
whether
where
they
does
would-
it end? How do I how do I find the limiting principle to the test that you're suggesting?
Well, first of all, the legislature defined how we make the determination, and these people are independent contractors.
But under Justice Wetland's example, they would be employees of Verizon because they don't meet they don't meet the three-part test.
If they met, no, well, I'm not, it's not clear whether they meet, there's
Well,
no
but-
evidence of control that Verizon controlled them. There may be some evidence, I don't know.
But what's the three-part test? The second part
Whether there
is
was control, whether what they were doing was part of the usual part of business of Verizon, and Verizon would say it's a telecom company providing telephone service, it's not a sales company, and whether the individuals had an independently established trade or business separate and apart. I'm not sure Verizon would meet that
How
test.
is that any different than when you apply the test to Credico?
Because I wish the court would focus a little bit on this particular facts of this situation. You have a company, Credico, a multinational company, that doesn't have anyone doing market and sales for them. It creates this network of 200 intermediaries who have really no assets, who are just individuals. And those people then utilize these workers. It's like the old farm worker cases where a big farm hires a farm contractor. There are many cases like that under the FLSA, and the farm contractor is held to be just an employee of the farm, not the employer. That is what this is.
What about the third prong? The individual is customarily engaged in an independently established trade, occupation, profession, or business. They're never going to meet that. Verizon's on the hook.
Well, no, it is possible that in a normal situation, that these workers would have gone out and done sales and marketing for a number of companies. This is an unusual situation. What if my clients had done some work for Credico, some work for others? They were independent salesmen. Those are independent contractors, and therefore they do have an independently established trade or business, as would the intermediaries if they actually went out and did business with other companies. This was closed. 100% of the work my clients did was for Credico, and 100% of what the intermediaries did were for Credico. This is an arrangement created by Credico. And please remember that in Di Pianti in footnote 17, you specifically said that where the larger company creates the agent of the misclassification, then they can't evade the purposes of the Wage Act. And there's at least evidence in this record that that was true, especially since they were independent contractors in this case.
So what's the evidence that Credico created the agent of miscalculation?
Yes, in the New York case, which is the Vasto case, there were, and in the record, and we cited this, there were 1,250 opt-ins in that case, I think, from all over the country. They all were independent contractors. And sometime in 2016, all of a sudden, Credico said, and this is in Judge Engelmeyer's decision in Vasto, we're no longer going to allow utilization of independent contractors. You have to have employees, and everybody became an employee. So there's at least some evidence in the record that Credico created the system.
So when you say some evidence in the record,
to-
counsel, that evidence you just told me about, that's not in the Vasco record, that's in this record?
Well, Judge Engelmeyer discusses it in his decision, as
Okay.
part of his decision. In addition to that, while we're on that subject, there is evidence in the record that Credico had specific control over these workers. I know this is hotly disputed, but I want to point out 2 points which I think are really critical. First, Credico had the right to order the removal of any agent on any project that the DFW was working on in this case. We've cited to you, it's at the record appendix 10, page 11, that if Credico objects to any of subcontractor's employees and subcontractor does not remove such person from the program, Credico may terminate the statement of work of this agreement immediately. So they do have the right to order the removal of someone lest the work be lost. Secondly, there's evidence in the record that Credico set the wage scale, the pay scales for these workers, that it wasn't totally independent. We put in the record
Set the compensation schedule for the franchisor who employs them, but they don't set, he's going to stand up and say the exact opposite, and I suspect he's going to be right, that they don't determine their hourly wage or any of that, right?
Well, that's what trials are for, and I would...
No, the trials are for if you have a dispute, but if we're going to find that there's no discussion of salary or payments, payments are, what the business receives is different from what the employee's
No,
compensation.
there is, Your Honor. I beg to differ.
Okay, all right.
On this commission schedule, which is in the Record Appendix 8, page 149, there's a schedule that is produced by Credico in this litigation, and it sets the commission for the rep. It says rep, and a dollar amount is listed, and owner, meaning the intermediary, and a dollar amount is listed. Judge Engelmeyer, in his decision in the Vasto case, said that this was a dispute of fact which he could not resolve.
Mr. Lichter, you're very, it's hard to pin you down on facts. What you just read there, the rep and the other, that's the franchisor, right? It's not the employee, right? It's the am I misreading that? Because I'm going to go back to that page and
Yes.
try to figure that out.
This is a document that Credico produced, which lists the amount of the commission that the rep would get, and it lists
The rep.
The rep is the agent, my client, sorry. And then it says what the owner
There's a
would get.
direct payment by Credico to your clients as opposed to a payment to the person who employs your clients.
No, in fairness, Credico took its share, then it sent the money down to the intermediary. The intermediary takes its share, pays some of the managers their share, although they're all independent contractors, and then pays an amount to my clients.
That qualification is just what Judge Salinger, I think, is talking about on the elusiveness of being able to find the facts from which the arguments are based in the business litigation session.
Yes, but I know I'm way out of time, but if I can just say one thing. The problem with applying the common law right to control test, although I think even under that test there should have been a trial, is that you allow, and this is what the Department of Labor has said and David Weil has said in his treatises, you would allow companies to completely evade the Wage Act by taking large companies who have lots of assets, creating penniless intermediaries, and then allowing these intermediaries to blatantly violate the Wage Act. And they were blatant violations here. My clients worked 60 hours a week and got no overtime and no minimum wage. I know there's a dispute about the overtime statute, but at least on minimum wage, they sometimes earn nothing or $100 or $200. And the court, by ruling that only the right to control test applied and turning blinders to the actual situation in this case, would allow these companies to violate the wage laws in a way that I think you have said on numerous occasions should not be permitted.
Okay, counsel, one final question just for me, and that is, turning to the argument of the amici, they suggest that the test should be a piercing of the corporate veil. Wouldn't that test help us distinguish between Verizon as an employer and Credico as an employer?
No court has ever adopted the piercing of the corporate veil. I'm not suggesting that that would be appropriate, nor do I think that's appropriate in wage and hour litigation. I know of no case that's ever done that.
Okay, thank you very much.
Thank you.
Attorney Miller.
Good morning. May it please the court. Barry Miller, and with me is Allison Silvera, both of Seyfarth Shaw, for defendant Applee, Credico USA, LLC. Before I
ask you
dig
to
in,
address Justice Cypher's question about piercing the corporate veil. Why is that not the right test?
yeah, I'm going to address several things that came up in Mr.
Excellent.
Lichtman's
Could you address
argument,
that
and
one
that's a
now?
good Yes.
Thank you.
Piercing the corporate veil wouldn't help here. It wouldn't make for a distinction because there's simply not record evidence that would allow for a piercing of the corporate veil as between DFW and Credico. We have a 12-factor test that lays out what plaintiffs
I
would
get
have.
that you can't pierce the corporate veil here. It doesn't sound like the facts sustain it. But why is that not the appropriate test?
Oh, it may well be. We actually think that the test announced in Cerullo, for example, is the correct test, that you should be looking for the immediate employer of these people, these workers, i.e. the person who hired them, the person who has the power to fire them, the person who supervises them, and the person who decides how they're going to get paid. And the record here is very clear on all of those
I
points.
agree with that point, but Mr. Lichten highlights something that troubles me, which is also what we were worried about in the last case, which is, at least for a period of time, there was basically treating these people as independent contractors when they weren't.
That was my
And that's
second.
a really, that time period creates, doesn't that put us into the Jet Pro analysis?
It doesn't.
Okay, why not?
For a couple of reasons. First of all of these people, by operation of law, were employees of DFW. That is the finding in Judge Salander's
But
summary judgment.
doesn't that hurt you then?
I don't think it does.
Because there's a period of time where you're sort of very involved in this relationship with the franchisor, and we have this position where the legislature's intent, which is to protect people who are employees from being treated like employees, is being violated for a couple of years, right?
I would say two things about that. First of all, there's no evidence whatsoever in the record that Credico was the agent of misclassification in the way that Mr. Lichten
Well, but
asserts.
isn't that, what, in Sebago and in Jet Pro, you guys lose that sort of protected status. Once we've got employees being treated like independent contractors, then we start coming down hard on why that's the case,
But-
including looking at the overall relationship between, in your case, Credico and then whatever it is, DFW or whatever the name is.
I don't think that second step is actually warranted, where we have people who are treated nominally as independent contractors, and nominally is important here. What we do is look to the entity that hired them, that paid them, that decided how they were going to be compensated, and we come down hard on that entity.
But
And what
don't-
that allows
Go ahead,
the
sorry.
business community to do is that when we subcontract a piece of work, we don't have to get involved in the employment and other contracting machinations of the subcontracted entity. We can and we should be able to stay out of that and let DFW manage its own affairs.
But does that become like a trial issue, like in Jet Pro or in Sebago? I'm just trying to understand why your situation is different there, particularly in light of that fight in footnote 17, where we're talking about the possibility that you willfully structured your relationship with the middle person here to do that.
The first point here is that this case was decided on summary judgment. It wasn't decided on a motion to dismiss.
What?
There was simply no evidence that Credico created this system or did anything other than the exact opposite of what Depianti considers. Credico here was the agent of appropriate classification. They said, you know what, we need to manage our business risk. We're only going to subcontract with entities that treat their workers as employees. And the reason they did that is also...
That 2 years later, don't they? They don't do,
They
they
do
only
it
do
in
that after they
2015.
get sued and clobbered in New York, right?
They won in New York. They won outright in New York. They won everything in New York.
Okay, so they-
and there was no trial in Sebago, and there was no trial in Janpro. Each of those cases resulted in a defense judgment. The other thing that I want to point out is that Mr. Lichten is not correct, that all the money here comes from Credico. As Justice Wentland pointed out, it ultimately comes from Verizon, from Direct Energy, and it does give rise to this really boundless standard, because any person who's working in your usual course of business becomes someone who may sue you for treble damages, attorney's fees, interest, and this statute has criminal penalties, which actually gives rise to questions about the rule of lenity here, where I could be held criminally responsible for the employment practices of an entity that I am at contractual arm's length with. I don't see how that standard is even something that this court could make sense of.
So what standard do we apply? Because we have to do a joint employer analysis here. You can't just stop. So, I mean, the piercing the corporate veil one seems impossible and has never been used in joint employer context in employment law, right? They don't
I
do
would
that.
argue that that's what Depianti contemplates.
Well, I mean,
But-
we've got joint employer cases in all different contexts, in employment discrimination, and it seems to be a well-established test. If you're piercing the corporate veil, is something we do very rarely.
So a few things. Joint employer is not a unitary standard. It means different things in different contexts. For example, for purposes of the workers' compensation law, it's different than for purposes of the pay equity law. And here, you have no statutory structure that contemplates anything other than the direct employer. Mr. Lichten and his clients are trying to take a statute that, as Justice Kafker characterized it, is designed to force workers into an employment relationship so that the Commonwealth can regulate their employment. That statute is not intended to open this up to potential liability for all of the other entities that regularly do business with that employer.
But hasn't this court opened that up some when there's an issue of misclassification, even if you're the innocent party to a certain extent in that misclassification, we've not ruled out that you've got to go do the next step, which is to figure out whether you're an employer. And we expressly said in, again, I can't remember, JetPro, whatever that case is called, that you don't need a contractual relationship with you to be potentially an employer, right? We've left this open.
Certainly, Depianti says that you don't need a direct contractual relationship to be an employer. What it doesn't say is that those people were in fact employees, and the outcome of the case was to the contrary. But there's a circularity posed.
Send it back to try that issue, right?
It's a somewhat complicated procedural history that's recited in the Vasquez case that the plaintiffs cite. What happened was the case got sent back down to the trial court before the Massachusetts federal trial court got to it. There was a parallel piece of litigation in Georgia that went the defendant's way, was reduced to judgment, and the Massachusetts court gave that full faith and credit, and that was the end of the case. But there's a circularity here. If we create a standard that requires the prime contractor to get into the business of the subcontractor and look at its affairs and make sure that it's doing all of these things. That's exactly what it shouldn't be doing. The entire structure here is that it should be able to subcontract the work and leave compliance to the subcontracted entity.
But we need a test. So I again, do not understand how a statute that determines who's an employee and who's an independent contractor answers the question, who's a joint employer. I don't understand that, but that's the first question, to know what you're dealing with. And then, what if the employer for that now employee, under that statute, under 148B, is just a shell? There's nothing there. We need a test. Is it the economic realities test? Does the control test really do it? We need a test.
So I would answer that in two ways. First of all, I'm not sure that we do need a test. We're talking about a statute here. We're not talking about a common law cause of action. And if the legislature wanted to reach through the hiring entity to get to Credico, Verizon, or anybody else, it could have done that. And in fact, there's a recent example of that out of New York. The New York General Assembly just passed a statute that is very much on point here in the construction industry.
It can't be that company X is really the employer and pulling all the strings, and this person is not making minimum wage, or there's other wage act problems, and they're not going to get paid, and it's, so maybe someday the legislature will pass the right statute. There has to be a second step in the test.
Well, there's existing law that would allow us to get through to an employer that was in fact pulling the strings. I think that's what piercing the corporate veil would do. There's no evidence that would support that conclusion here. If we needed a test at all.
But you lose if we use that test. If you need a test, because otherwise you lose. Because the test, you fail that test.
Which test is that, Your Honor?
The test set out in the wage law, says you're an employee if you're not if you don't meet these three things. So you're in trouble if that's the case, isn't it?
I don't think that's the case, actually, Your Honor, and Gallagher talks about this. So Gallagher is easy to misinterpret, and I misinterpreted it myself the first several times I read it. But there are two separate analyses there. One is, are you performing services directly for this entity? If so, we'll apply 148B, the ABC test. But you have to get past the first phase. You have to show that these workers are providing services directly to the defendant entity, and you don't have that here for reasons that Justice Salinger described in his summary judgment opinion. And that gets me back to the second part of my response to Justice Lowy's question, if we do need a standard. And I maintain that we may not, because this is statutory and the statute goes as far as it goes. But if we do, that standard has to allow a party who ultimately could be held liable for treble damages and criminal penalties to avoid that outcome without taking over the business of a subcontracted entity. And if the economic realities test is essentially attuned to that. And you look at facts like who set this person's compensation.
But I'm confused, though. In the 2 year, if Mr. Lichten is right, that there's 2 years of time before the employment relationship is formalized. So we have 2 years in which they're acting as independent contractors when they're not, according to this test.
That gets me back to something that I
But
said. Sorry.
then we have this free-for-all between your company and the intermediary. Isn't that exactly what we did in DiPiante?
No, there's no free-for-all because it's very clear who hired these people. If we're looking for one employer, there's no question who it is. Jason Ward hired all of these people. By the way, it's not true that all of them were treated as independent contractors for that period. Okay. Several of them started after the DFW had switched over to a full employee status. But the other important part of the response to that is what I mentioned a few minutes ago about these folks being only nominally independent contractors. There was no difference in treatment, no difference in the way that they were paid as between the time that they were independent contractors and employees. They were always paid strictly on commission and at rates established by Jason Ward and DFW. And that gets to the document that Mr. Lichten pointed
So
to.
Mr. Lichten's brief is going to say that because of the compensation structure that you set up and everything else, including that you can is he accurate to say that you have the power to get rid of them, get rid of all these people? Because that's an unusual power for a company to have that's not an employer.
It makes sense in context. If you look at the contract that Mr. Lichten referred to, there are provisions in it that talk about ensuring that there's not fraud or really criminal activity by these workers. And under those circumstances, if the end client, Verizon, insists on the removal of that person, you have to do it. That is the extent of the power that is even contemplated. By the way, there's no evidence that it was ever exercised even
So
once.
there's no corresponding responsibility or power for Credico, just for Verizon?
Correct. The contract reserves essentially the right for Verizon to require that a given worker, for example, who has engaged in fraud, not be selling
But
Verizon
Credico could
phones.
not do that.
I don't believe so under the contract, not at will, not for no reason. And more to the point, there's no evidence that anybody did it. One thing that is clear is that the compensation practices and all the hiring, all the firing, in fact, was done by Jason Ward. And there's even testimony in the record from Lee Tremblay, one of the plaintiffs, to the effect that he understood that Jason Ward set his compensation, determined how he would be paid, and he was aware of other intermediary entities, we call them ISOs, who made different decisions about how to pay people and paid their workers differently. So all of that was going on at the subcontracted entity. Under those circumstances, there's just no basis for a finding that Credico exercised sufficient control or even had sufficient control to exercise to put itself in a position to avoid the draconian penalties of the Wage Act.
Well, we've got, obviously, Judge Salinger was very critical of the plaintiff in laying out what the genuine issues of material fact were. And the plaintiffs pushed back on that in their brief, and you make the comment you make. And then Judge Salinger applied the control test. If it were the plaintiff's facts, does the case come out differently if it's the economic realities test?
It's difficult for me to conceive of exactly what the plaintiff's facts are because I think they've drifted a little bit. I don't think there are any facts supported by any record evidence that gets them anywhere close. And Judge Salinger made that same conclusion. He poured through this record and went to pains to do it, as he describes in the decision, and he drops footnote after footnote about how the assertions that plaintiffs make simply aren't supported by evidence. And again, this is a summary judgment decision. It's not a motion to dismiss. And fundamentally, plaintiffs had a full opportunity to gather evidence that would support these facts, and they failed to do it. The record simply doesn't support that, and summary judgment for that reason was entered appropriately for Credico.
Okay, one more question. I know your time is up. Can you address getting rid of Jackson on the issue of claim preclusion?
Yes. That's a little bit more of a niche issue, but I think it's actually quite clear. And Justice Salinger dealt with two separate instances of that. The original plaintiffs were dismissed from the case on the same grounds. I don't know why they didn't appeal and Mr. Jackson did. But the gist of the rule against claim splitting is you can't file a lawsuit against somebody and keep claims in your pocket. So if, for example, you file a lawsuit against Credico in the Southern District of New York, as Mr. Jackson did when he filed an opt-in consent form, giving him full status as a party, by the way. The Genesis healthcare case in the briefs from the Supreme Court says that. These folks are parties. So in effect, Mr. Jackson sued Credico, and he advanced only a claim under federal law, the Fair Labor Standards Act. He never did anything, never even sought to assert a Massachusetts claim in that action. And so when it was reduced to judgment against him, any claim he could have had is dead and has to be dead. Plaintiffs would like the court to engage in speculation and say, well, the Southern District of New York might not have allowed that because the Massachusetts claim was discretionary. But that is exactly the argument that this court's rulings on this subject preclude. In the seminal case of Anderson versus Phoenix at 387 Mass 444, page 451, the court said, we cannot countenance a plaintiff's action in failing to plead a theory in federal court with the hope of later litigating the theory in state court because it was possible or even probable that the federal court would have declined to exercise its pendent jurisdiction. Rather, such a plaintiff should plead his state claim in the federal court, and if that court fails to hear the claim, the plaintiff may then ordinarily file suit in state court. That's exactly this case. That's exactly what Mr. Jackson did, and this court has already ruled on it.
Can I ask one more question on the salesperson issue? Is there a different definition for minimum wage versus overtime?
No, actually, and that raises a thicket of issues. The statute contains very few exemptions from the minimum wage obligations that it imposes, and those occur only in Section 2, where it defines out of occupation certain categories of people, including sales folks who never make visits to the office or who do not make daily visits to the office. But the Section 1A, which enumerates the overtime exemptions, separately includes a salesperson exemption that is not met with similar language about not making visits to the office.
So is that why there's a difference? Is that your position, that that explains the difference?
Yes, and it's actually syllogistic, because Section 2 was passed in 1947. And what it does is say, if you're a salesperson who never makes visits to the office, you're not engaged in an occupation, you're not covered by Chapter 151 in any respect. Minimum wage, record keeping, overtime, it just doesn't apply to you. Section 1A, which was added in 1960, 13 years later, merely says if you're an outside salesperson, you're exempt from overtime. And so if plaintiff's theory that these two sections meant the same thing were true, what that means is that in 1960, the legislature decided to pass a statute that says this group of people who are already exempt from every aspect of this statute are exempt from one narrow little bit of it. That doesn't make any sense at all. And so if we know that the definition in Section 2 does not swallow the definition in Section 1A, as plaintiffs contend, then where do we look for that standard? And Judge Salinger, I think, appropriately looked to federal law because it uses exactly the same term, outside salesperson. And under that standard, as was found in Vasto, as was found in Martin, these folks were categorically outside sales personnel. And the last thing that I would like to add to that is that those same cases also reject plaintiffs' fundamental contention here about what Credico is. Judge Engelmeyer in the Southern District of New York engaged in factual finding on a record there. And he said, this is a completely normal run-of-the-mill business. It is commonplace to outsource these sort of marketing services. And in fact, with respect to Sprint alone, it was one of many brokers that engaged in that sort of thing. So all of the aspersions that plaintiffs want to cast on this company and this business model have already been rejected by 3 separate courts, Judge Salinger, the Southern District of New York, and that ruling was upheld by the Second Circuit. There's simply no basis for a finding that Credico was liable to these plaintiffs for anything. And for that reason, we would ask the court to affirm the ruling below.
Okay, thank you very much.
Thank you, Your Honor.
We'll take our morning break.
All rise.